Hello everyone, and welcome to this video tutorial in which we're going to be doing some A-level law revision, and we're going to be taking a look at a tort exam question that is asking you to evaluate the law on negligence. The question that we're going to look at a suggested answer for is this one here, where you're being asked to discuss the problems with the law on negligence. So this particular question is not only asking you to outline, explain and describe the law on negligence, but it wants you to analyse and evaluate those rules. So you need to be doing two things, explaining what the law is, but also analysing and evaluating whether those principles and those concepts are logical, whether they're fair, whether they lead to any particular problems in the law. So I'm going to look at this model answer with you that I've got on the screen here, and I've colour-coded it to try and make it a bit simpler to follow. Notice straight away that I've got some green subheadings here. Now, I don't suggest that you use subheadings in the exam, but the reason that I've included these is just to try and make the essay answer easier to follow on the screen for you watching the video. In your particular essays, in the A-level law exam, I wouldn't put headings in. I would just write it as a free-flowing essay. But you'll see in the green font there, I've highlighted what the key problems are with the law on negligence. And you might like to take those and write yourself a bullet point plan with them. So the key problems are the need to prove fault, the fact that the law has developed in an ad hoc or case-by-case basis, that we have a lot of inconsistent decisions in the law, we have a lot of tests that a lot of the time are quite vague and difficult to predict the outcome of. We have a lot of conflicting decisions on the public policy leg of the Caparo test, and we'll go through all of these. We have a problem deciding when doctors are going to be liable for medical negligence. We have problems associated with the use of juries in tort law. And at the end here, you can see I've got a conclusion and possible reforms. So that green font, those green headings, could be a nice essay plan for you if you're going to practice writing an essay up on this area. In the black font, I've got where I'm just explaining a rule, I'm just stating a rule, I'm stating a fact, I'm stating a case. I have highlighted the cases as well in yellow so that they stand out a little bit better. And then in the red font, that's wherever there is analysis and evaluation. So by colour coding, hopefully you can see that in this essay, there's a nice balance of black where I'm just explaining the law and red where I'm evaluating. And in fact, you'll notice with this essay, there's much more red, there's much more evaluation really going on than there is black font just explaining the law. And that's a good thing because, of course, evaluation is a much higher level skill than just simply describing or stating a fact. So you can see that generally speaking, I sort of state a fact and then where possible try and evaluate it. And that's a nice approach for you to take when you're trying to evaluate an area of law. Go through this essay in a bit more detail then. So as I've said, the subheadings are just so you can follow it on the screen. I wouldn't have them in the exam. So we'll just ignore them as we go through the rest of the essay. So I've started off with a bit of an introduction, and in your introduction, you always want to link back to the question wherever possible. So I've started off by saying there are many problems associated with finding liability in negligence. And then the first problem is associated with the need to prove fault. And then I've outlined the Caparo three-stage test for negligence requires that the claimant proves that the defendant was actually at fault. And the reason that that's problematic is because proving fault is going to be costly to the claimant, particularly if they need expert evidence in medical negligence cases. That can be very expensive indeed. And this may mean that some people can't even afford to bring a case in the first place. And I've mentioned here that although there are some no-win, no-fee agreements available, many of these actually require a 70% chance of success before they're even going to take on the case. Also related to the need to prove fault, is that it results in delays, because again, if you're having to prove fault, and there might be multiple insurance companies involved, that's going to be time consuming. And also, this system's very intimidating to parties, it's adversarial in nature, and it requires a degree of confrontation. The second problem in proving negligence results from the fact that the law of negligence has developed on an ad hoc or a piecemeal basis, gradually over time through judicial decisions. Starting, of course, with the famous decision in Donoghue and Stevenson, in that case where Lord Atkin, I'm sure you remember, came up with the neighbour principle and decided that manufacturers owe a duty to the ultimate consumer of their products. Now, that where judges are making law is undemocratic because judges aren't elected. And ideally, we want Parliament to be making law, we want to have parliamentary sovereignty, we want to have separation of powers. And since negligence is essentially concerned with a conflict of values within society, judges are in essence making political and moral value judgments, and they don't necessarily have the knowledge or the experience to do this. And as we've said, it's an undemocratic approach. And the fact that we've got judicial decision making happening links quite nicely to our next problem that we're going to talk about, in that there are inconsistent decisions. Because obviously, if you've got different judges just making decisions on different days rather than following Acts of Parliament, there's bound to be inconsistencies. So negligence is based on fault, but in Nettleship and Weston, this is a nice example to give. A learner driver was driving at the best of her limited abilities, but she was still found liable in negligence. And you could talk about the fact that morally she was not at fault, but she was found legally at fault. And this shows that the traditional concepts of negligence have been manipulated, if you like, by the judges to focus on apportioning losses. Or in other words, the judges have looked at who's going to carry the cost, if you like, for paying for this negligent act, for the damages that have resulted. And some argue that this is introducing no-fault concepts into negligence through the back door. And that the fact that the learner driver was insured was considered by Lord Denning, who decided the case of Nettleship and Weston. And this is a quote from Denning. And he says, "We are beginning to apply the test on whom should the risk fall. Morally, the learner driver is not at fault, but legally she is liable to be because she is insured and the risk should fall on her." And this shows confusion about the very basis of the tort of negligence. Our next problem is that there are lots of vague tests in negligence, and again that links quite nicely with the ad hoc development and the inconsistent decisions that we have. So there are lots of vague tests for negligence. The law of negligence, as we've mentioned, originated from Donoghue and Stevenson, and Lord Atkin's neighbour principle talked about acts and omissions. But actually the law treats liability for acts very differently from omissions. And Lord Atkin's test doesn't mention the need to identify the type of loss which the neighbour is likely to suffer before any decision can be made about whether to impose a duty. It's also unclear about the degree of proximity which will be required in situations other than the manufacturer and the ultimate consumer of their products. We could also talk about the vagueness of the Caparo criteria, and it's impossible to define the concepts of reasonable foreseeability, proximity, fair, just and reasonable in concrete terms. Reasonable, of course, is that word that lawyers love, and it's the bonus of it, I suppose, is that it's very flexible. It can cover lots of situations that may arise, but we can't really give a concrete definition of these tests that have come from Caparo. Instead, we just sort of look at the cases and try and reason by analogy. The next problem are the public policy decisions, and a lot of these cases are now conflicting, and we fairly recently had the case of Robinson on this as well. So you could talk about how the tort of negligence sometimes makes decisions on grounds of public policy. So the fair, just and reasonable test has allowed the courts to decide that if a public service such as the police are acting under pressure, it wouldn't be fair to impose a duty on them. And you could talk about the case of Hill and the case of Osman here. And following the case of Hill, which was the Yorkshire Ripper case, if you remember, where the last victim of the Yorkshire Ripper, her mother tried to make a claim against the police. And following that case, it was believed that the police would be generally immune from negligence claims in respect of detection and investigation of crime. And that was actually challenged in the European Court of Human Rights. And is in Osman, the European Court said that in striking out the claimant's claim on grounds of fair, just and reasonable, the Court of Appeal had denied them their human rights to a fair and public hearing, as guaranteed under Article 6. And to add further confusion, in the case of Z in the UK, the European Court of Human Rights changed its mind about that. It changed its mind about its decision in Osman and said that striking out claims didn't actually breach Article 6. Once again, this same issue arose in the case of Robinson from 2018. And in this case, our Supreme Court said that Hill doesn't grant the police general immunity and that the police can be liable for negligence that results in personal injury. But the fact that we have these conflicting decisions shows that there is a lot of confusion in the law, and not just here, also in the European Court of Human Rights, about when the police should be liable for negligence. The next problem is in deciding liability for the medical profession. So not only have we had difficulties in determining liability for the police, we also have it with doctors as well. The Boland test has been heavily criticised as being too heavily weighted in favour of the professions, because that particular test basically says that doctors can avoid liability just by showing that some other body of professionals would have done the same thing. So I saw somewhere a quote, I mean, I wouldn't necessarily put this in an exam, but it was sort of criticising the rule, saying, as long as you can find some other bozo that would have done the same thing, you're not liable. I mean, that shows how problematic that test is. And that rule allows the professions, in essence, to determine their own standards and codes of practice. It's also unclear what a reasonable body of opinion within a profession would be, how many persons would be in such a body. But to be fair, without the Boland, people in certain professions would be deemed as easy targets. We would arguably cause floodgates of litigation to be opened. So there is some sort of bonus or positive to have in the test, I suppose. An additional hurdle for the claimant in medical negligence cases is going to be where there are multiple possible causes. And you could talk about the case of Wiltshire and Essex here, where it was impossible for the claimants to prove which one of 5 possible things had actually caused the baby's blindness. And it seemed unfair that since the junior doctor had clearly been negligent in giving too much oxygen, he escaped liability just because there were other possible causes. So that seems like an unfair decision. Could also talk about the problem associated with juries. So the Pearson report found that almost 1% of hospital admissions resulted in a mishap due to negligence, and that only 1 in 25 of these patients were compensated. And the use of a jury-based system in medical negligence cases has been attacked related to this. And juries aren't going to have necessarily the relevant knowledge, sufficient information to adequately determine what's a reasonable level of care. They've also been, as you'd imagine, inconsistent in their approach to whether damages are related to the severity of the injury or the degree of negligence by the health professional. And again, this emphasises the problem of fault as a determinant of liability for negligence. And we're reaching our conclusion here that you might compare the situation here with Canada and New Zealand and compulsory insurance like an American